Hi, everyone. Samantha Fitzgerald here. Thanks for joining our webinar. We're going to give this maybe about 2 minutes to let everybody else join in. We have several people on already, but it is dinner time and people might be fighting with traffic, so we'll give them just a second. Well, 2 minutes. And I'm slightly under the weather, so hopefully everything goes okay. I have my glass of water here, so I think everything will be fine. You are not muted, Leslie, so you should be able to hear. Can anybody else hear? Okay, so nobody can hear. Jenny? Oh, no, you're muted. I'm not muted. Okay, Marie can hear us, so then that must be Leslie. Okay, now Marie can hear. Leslie, can you hear us? Lisa can hear us. Stephen can hear us. This is the first webinar I've ever done, so it's a little weird when you can't see the other people. I've done a gazillion Zooms, but my first actual webinar. So, all right. So Leslie, hopefully you are able to turn your volume up and hear us. Give us a thumbs up if you can. Okay, it's 6:02. So for those of you who are prompt, I am going to get started and everyone else can join in. So thank you so much for joining us at our webinar. This is Estate Planning 101 for busy professionals. My name is Samantha Fitzgerald. I am the founder of SJF Law Group. We're located in Plantation, Florida. I've been practicing law for 25 years. Can't believe it. It flew by. 25 years. All we do here are trust and estates, so estate planning, and then probate and trust administration. And under that umbrella, we also do pre and post nuptial agreements. We do not do any litigation, so everything's nice and friendly here. Let's see. Throughout this webinar, we're going to be doing a couple of polls to keep things interesting. So you will see them pop up over time. So feel free to participate in that. Most of you know how to work that chat already, as we can see. So feel free at any time to post questions in there. We have Jenny on with us. Her camera's off, but her microphone is on and she can hear what's going on. She is our marketing director and our moderator of this webinar. So she'll be checking everything out. And if I miss any questions, she'll let me know. We also have some handouts. I'm not sure what it looks like on your end. On my side, it's at the top right. It says handouts. So a couple of things that you can download and hopefully you'll find useful. One is a ladybird deed versus a revocable trust infographic. So we get a lot of questions on what's the difference between ladybird deeds and revocable trusts. So hopefully that will answer a lot of your questions. And then the other one is an estate planning checklist. So those are very helpful guides. We also encourage you to follow us on social media. We post lots of interesting information and short videos. If you sign up for our newsletter on our website, you will get lots of great information, both about the firm and lots of trust and estate tidbits that hopefully you will find useful. If anybody ever has any suggestions on topics, feel free to send them our way. We love hearing from everybody and providing information and resources and content that are helpful for everyone. So that is a picture of our team, 9 women, and we all get along. It's an awesome office. Okay, so I think if you click on the the Bitmoji there, you'll be able to follow our social media. Jenny, if I hit close on that, is it going to go away for everybody?
No, you can hit close. It's just, it'll just be related to that person's screen.
Okay. Great. Okay. All right. I think I did all that. All right. So our first poll, we're going to start with, how many people have an estate plan? Let's see where we are. Okay, very good. 50%, more than 50% have one, even though some might be outdated, but that's great to hear. We love to see that. So that's wonderful. All right, move along here. So what is estate planning? I think this term is not a great one because it is confusing for people. People confuse it with family planning. The term seems to signify that you need to be very wealthy to have an estate plan, or that you need to be elderly, or that it's just something you do to plan for death. And that's not the case. Estate planning really encompasses a lot of different things, both during your lifetime. So preparing for incapacity, making sure that people have legal authority to be able to actually help you make both medical and financial decisions. And then it is also upon your death and making sure that things go where they're supposed to go, the right people are in charge, you're reducing the fighting and the conflict amongst your family members, and making sure things aren't a complete mess when you go. But a lot of it is relevant while you're alive for your incapacity or your diminished capacity, right? Because it's not all about just being incapacitated. There's oftentimes a long road of diminished capacity before you become, if you ever become, incapacitated. And that time frame, can be very stressful on the family as well as yourself. So making sure that you have legal documents to give somebody authority to be able to help you is really important. Okay, I'm going to put my chat back so I can see if there's any questions there. All right. Again, don't hesitate to ask questions. That's why we're here today. So feel free anytime. Okay. So what happens when you don't have any documents in place? Well, chaos. If you've ever, seen this in action, you know what can happen. Lots of unwanted outcomes. Lots of instances where the wrong people inherit, unanticipated outcomes. For instance, I met with a couple this week, and they had been married for many, many years. They had one child together, no children outside of the marriage, but it just so happened that the primary residence was only titled in one of their names. It's actually quite common. People own property before they get married. They end up living together, but one of them owned the property beforehand. Or sometimes a spouse is traveling, believe it or not, and the spouse who's here, not traveling, closes on a property. And even though they intended to buy it themselves, the title ends up being in only one spouse's name, and they just never change it. So in that instance where the one spouse owned the property, they had one child together, if that spouse died, the surviving spouse would not get 100% of that house. They would get a life estate with the remainder passing to the child, who was an adult. But it wouldn't matter whether they were an adult or a minor child, it would pass to the child. So the child would actually be on title with the parent. And that is a disaster and a really unanticipated outcome. Without having documents in place, there's also lots of confusion. What did mom and dad want? What are we supposed to be doing with this? How do we run this business? Who gets this item? Who gets the diamond ring? And of course, conflict. Lots and lots of conflict. I had a meeting with somebody just today. Somebody actually did have some documents, but they weren't really clear on what was to happen, and there's conflict over a profitable business. So that's a problem. There's lots of difficult decision making. What if you're ever on life support and your family doesn't know what your wishes are? Or I had somebody call me once and say, we don't know what she wanted. We didn't know if she wanted to be buried or cremated, because there was never a discussion. So documenting these things and having some legal documents in place is really important. And then, of course, there's probate and guardianship that can be triggered without having the right documents in place. And those are a disaster. If anybody has ever watched that movie on Netflix called I Care a Lot, you know what I'm talking about. And if you haven't watched it, it's a great movie. I highly recommend it. It's entertaining, but sadly, it's pretty close to reality. It's a good flick, so give it a try. But that is something you definitely want to avoid. So having documents in place is really, really important for many reasons. Okay, any questions yet? Feel free to put them in the chat. All right, next. So what is probate? So, all right, we're going to do another poll now. So how many out there have ever had to probate somebody's estate? Let's see if anybody's had to. You could either say you were the executor, which is called different things in different places. In Florida, it's called personal representative. Or maybe you were a beneficiary of a probate administration. Let's see, we've had. No, okay. Well, then you don't know the pleasure of doing it. It is a thankless job being a personal representative or an executor of a probate administration. So probate is a court process to transfer your assets to your beneficiaries. It is, I always refer to it as a title transferring process. It is not always required, and it is sort of easily avoided. You will never know if your estate needs to go through probate until the time of your death, because it is based upon the assets that you own at the time of your death. And it's based upon how they're titled and whether or not somebody is designated as a beneficiary on them, or whether they're jointly owned. So things that don't go through probate. If you jointly own an asset with somebody else, and that somebody else is still alive, and the titling is joint tenants with rights of survivorship, it does not go through probate. It goes directly to that joint owner. So an example of when this doesn't happen, real estate, it must say, unless it says husband and wife, and that's called tenants by the entireties, and that is a form of survivorship ownership. But if it's just with an unmarried couple, let's say, and if it just says Bob and Mary, and it doesn't have any language about with right of survivorship, then it's what we call tenants in common. And that means that you each own your half, or whatever percentage it is that you own. And if you die, your half has to go through the probate process. This is oftentimes a big surprise to people. We get called in a lot when a property is about to sell. So it's almost at the closing, and they realize that one of the owners is dead and there's no survivorship language in there, and it has to go through the probate process. So joint assets that are not with right of survivorship go through probate. Individually owned assets, unless they designate a beneficiary. So you can't really designate a beneficiary on real estate, but you can on financial accounts. And that is true for life insurance, retirement accounts, whether they be 401ks, IRAs, checking accounts, savings accounts, brokerage accounts. On almost any financial account, you can designate a beneficiary. Occasionally, a financial institution doesn't allow it. Most of them do. And they are called different things. It could be POD, that means payable on death. That's usually for cash accounts, like a regular bank account, checking, savings. Then there's TOD, transfer on death. That's for some sort of brokerage account, like stocks and bonds, because they don't pay it to the beneficiary. They actually transfer it over to the beneficiary. Some brokerage accounts, financial advisors have other kind of odd terms for them, but that's basically it, that they're all synonymous for beneficiary designation. And if you have designated a beneficiary on there, then that account goes directly to the beneficiary. It does not go through the probate process unless the beneficiary predeceases you. We get that a lot more than you would think. In that case, then there is no beneficiary, and it's back through the probate process. So in the probate process, there's two different kinds of probates in Florida. Oh, one more way to, well, two more ways really, to avoid probate, or things that don't go through probate. Anything that's in a trust. So the trust itself will control the disposition of those assets that are in the trust. And then there's something called a ladybird deed or an enhanced life estate deed. And that is sort of like naming a beneficiary on real property. It's a little different, but it's similar to that. So you designate somebody that will receive the property upon your death, and you retain what's called a life estate in that property. What makes it a ladybird deed or an enhanced life estate deed is that the owner retains all of the power over the property until they die. So they retain the power to sell, to mortgage, to convey, transfer, gift, any of those things without the beneficiary, which is called the remainderman, without their consent. A true life estate deed is, in that case that I mentioned earlier, where the spouse was the only one on title and they had one kid together. A true life estate deed is where the life tenant and the remainderman are both actually on title, and they both actually own the property and can't do anything without one another. Okay, so if you have something, if you die and you own something that doesn't pass according to one of those ways that we just discussed, then it has to go through the probate process. And probate is very different from state to state. It's very different from county to county, even here in Florida. Although the rules are the same, the statutes are the same, the probate rules are the same statewide, every county has their own procedures, and every judge likes things their way. So it's always very, very different. Anytime we file a probate administration in a different county, you have to get to understand that their particular rules. For instance, in Miami-Dade County, they almost always require a restricted bank account. We call it a restricted depository. So anytime there are liquid assets in Miami-Dade County, they have to go into a bank account that we have no access to without a court order. So every single time we need to get money out to pay taxes, to reimburse somebody for advancing expenses, to pay the mortgage, to pay legal fees, to do anything, we have to file a petition with the court, and we have to get a court order. We have to provide that court order to the bank, and then they release the funds. It's a lot of extra work and it's a lot of extra time, because the court will almost always require that you either get consents from all the beneficiaries, or that you notice them and give them an opportunity to object. Oftentimes the court comes back with additional questions or additional information that they want from us. So it can be a very lengthy process. And it's out of our control. You know, you're at the mercy of the court and the judge, and they're humans, and sometimes they're in bad moods, and they're definitely overworked. They have a lot of cases. We had a case in, I forget the county, recently, and their normal turnaround time for an order was 30 to 45 days. I couldn't believe it. All we were trying to do was get into a safe deposit box. It's incredible. So let's see, any questions? Okay.
We have one question in the chat.
Is it better to have a will or a trust? So that's a great question. And the answer is yes. They're completely different. So you really need both. Oftentimes you see people with a will without a trust, but you usually don't see the opposite. You don't see a trust without a will. So a will only controls the probate process. That's it. So going back to our discussion here, what is probate? Probate is triggered by the assets you own at the time of death, not by do you have a will, do you not have a will. A will is meaningless other than it controls the process once you're in the probate court. So you get into probate with your assets. So if you have an asset that's in your name, not jointly owned, no beneficiary, no trust, it has to go through the probate process in order to be transferred where it's going. So a trust is one of the ways that we avoid the probate process, but only if it's properly funded. So a trust can only manage the assets that are actually in the trust. So I see a lot, people have their estate plan and they have a trust set up and they never do, they leave their lawyer and they never do anything with it. And all their assets end up going through the probate process because they never retitled anything. They never put anything in their trust. They never properly funded it. So part of what we do here, we spend a lot of time talking with our clients and educating them and giving them instruction on what to do to make sure that everything works the way we intend it to work. So you would typically have a will and a trust. And when you have a trust, it's usually called a pour over will. So it's usually a very simple will. And if something goes through probate, the will is going to capture that asset and pour it over into the will, the trust, pours it over into the trust. And the reason we want to do that, why that's so important, the trust has lots of protections in it. We'll probably talk about this a little bit more later, but a trust will have protections, creditors, spouses, incapacity, disability. If we don't have the will that's going to be that safety net and catch that one asset that slipped through the cracks and went through probate, then it's going to pass outright. So it's going to pass under what we call the intestacy laws. So when you don't have a will, you die intestate, and then your assets pass to your heirs, whoever they are based upon the law. And that depends on who's alive. So it could be your spouse, it could be your children, it could be your parents, it could be your siblings, it could be your nieces and nephews, it could be more remote beneficiaries. And if any of them have any problems, then we want the will to scoop it up and put it over into the trust. So the will and the trust are kind of connected together. So you should definitely have both. All right. Next question. And second marriages, we'll talk a little bit more about that in a minute. 120% really need estate planning. We saw an instance once where there was a marriage, second marriage, and the husband had no children. The wife had 3 children. They were old and, an older couple, and all their assets were jointly titled. So when the wife died, everything passed to the husband. Okay, no probate. Well, he died 3 months later, and everything passed to his siblings. Nothing passed to the woman's children. And it was like $3 million. His siblings were in their 90s, had no intent of sharing, and her kids got nothing. So that was really, really, really bad situation as a result of no planning. Okay, if our home is titled in the name of our trust, but we have a mortgage, what happens to the mortgage upon our death? Does the home need to be refinanced, or can beneficiaries continue our mortgage rate term if they do not want to sell the property? So good question. So let me break that into 2 pieces. One is a creditor question, and I'm going to expand it beyond mortgages. So the other bad thing about probate is that we have to notify creditors. The personal representative has a fiduciary obligation both to beneficiaries and to creditors. So the personal representative has to make a diligent search for any creditors of the decedent. They got to look through their paperwork. They have to look through their mail, maybe look at their tax return, check into their checkbook if they have one, and really look around and make sure that, any debts that might be out there are going to get paid. Oftentimes we pull a credit report because, a lot of times the personal representative doesn't know what the debts were. So you have a fiduciary responsibility there. Then we have to publish notice in the newspaper if we're doing a formal administration. And any creditors we're actually aware of, we have to actually give notice. And then during this creditor period, it's 3 months from the time we publish that the creditors have time to submit claims to the court. And if they submit claims and there are assets, they have to be paid. If there are no assets, then maybe they get paid less or they don't get paid at all. Or if they don't submit a claim, which happens a lot, then they don't have to be paid at all. So the creditor is just out of luck if they don't submit a claim. So what's different about a mortgage is that it's a secured creditor. They have a lien on your property. So no matter what happens, your mortgage is going to have to be paid, or they're just going to repossess the property, whether it's in probate, a trust, it passes by a ladybird deed. Regardless of what happens, the mortgage is the mortgage. It stays there. As long as the correct way is for the mortgage to be paid in full when somebody dies. But a lot of times that doesn't happen. And as long as the payments are being made, I've never once seen a mortgage company, have a problem with that. They really don't pay attention to it. The payments are coming in, it's getting processed. It looks like it's, still paid on time. So it's usually not really an issue. Could they call in the mortgage and say that it needs to be paid in full? Yeah, they could. But again, I never really see that. Where you do kind of run into trouble, though, is the mortgage itself, the debt, stays in the decedent's name. So even though we've transferred title either into a trust or through the probate administration or through a ladybird deed directly to some beneficiaries, the remaindermen, the debt and the mortgage are still in the decedent's name. So sometimes people will have trouble calling and getting information about the loan. So, this is a tidbit is, have your online login information available, because if somebody can just log in and get that information, it's great. Sometimes people impersonate the decedents, if they're both female or they're both male, and they just call. If you have the information, you might need social security numbers or dates of birth, if you want to get payoffs or balances or find out when the next payment is due or stuff like that. So hopefully, so where I did also want to say with claims and creditors, paying of creditors, aside from secured creditors, happens in the probate administration, usually only. So if assets don't pass through probate, they're either passing by beneficiary designation or through a trust. Oftentimes, creditors never get paid. They could initiate a probate and try to go after the assets and get paid that way. It usually never happens. Maybe a really, really, really big creditor might do that, but typically it doesn't happen. So if there is no probate, typically the creditors are not getting paid, and that's legal. But if there is a probate, you have to notify creditors, they submit claims, you have to pay them, which can be, a big bummer, obviously. And one more tidbit, 2 years after somebody has died, all claims are barred, except for the federal government. But everything else, just gone, wiped out. It doesn't matter if the decedent owed, $1 million in medical bills or credit card bills or loans or anything. 2 years after somebody has died, all claims are barred, unless a claim had been submitted previously in the probate administration, and then they've perfected their claim. Okay, I missed the very beginning tonight. Brokerage account includes designated beneficiaries. Does that supersede any conflicting direction from a will or trust document? Excellent question, Craig. And the answer is yes. This is a tough one for people to understand, because I sit with a lot of people and they say, I've designated Bob as beneficiary on my account. And, my will says the account is going to go to Betty. So Betty gets everything. And I say, no, Bob gets it. And the reason being, override is not technically correct, but that's an easier way for everybody to understand it. The actual reason is that account never comes into the probate administration. The will only controls the probate process. It says who gets what and who's in charge, but it only has control over the probate administration and the assets that are in probate. So since the POD or the TOD never come into the probate, doesn't matter what the will says. It has absolutely no control over that account whatsoever. Next question. Is a land trust the same as a regular trust? How much does it cost to set one up? Another good question. We get that a lot. Oftentimes we have people calling, asking, saying, I want a land trust. But when we dive into it a little further, we realize they don't really know what they're asking for or why they're asking for it. And maybe they heard about it or a friend mentioned it. A land trust is really a real estate concept. It's not an estate planning concept at all. Usually there's no beneficiaries designated in a land trust. It's more of an anonymity thing. So real estate investors may use this to designate somebody in the public records as the trustee of a land trust that's holding real property. And the real owners are never disclosed. You don't see them all that much really in Florida. It's not an estate planning tool. It's something that like they hold bare legal title. It's not a replacement for like a beneficiary designation or avoiding probate. It's not the same as a revocable trust. Revocable trusts are the most common thing that you see in estate planning. I love the questions. These are great. Second marriage, I have a will. My husband and I do not live together. So, okay. So second marriage and you have a will. Great scenario because a lot of people will think that they're protected here. So, you die. What happens? Well, let's look at what are your assets and how are they titled and what beneficiaries are designated on them. So if you have any real property, if it's just in your name alone, it's going through probate, your will controls. If you have financial accounts, but let's back up a little bit. If you own a property with your spouse, it's going to your spouse. Doesn't matter what your will says, doesn't matter where you want it to go, it's going to your spouse. Homestead is a very tricky one. So if you own your primary residence, we kind of talked about this earlier, and you die and your will says, I leave it to my kids, but you're married, your primary residence goes life estate to your spouse, remainder to your kids. If you have no kids, your spouse gets 100% of it no matter what, even if you've designated somebody else to get it in your will, because you can't leave your primary residence to anybody other than your spouse if you're married. If you have minor kids, you can't really leave it to anybody. Lots of restrictions with that. So let's say you've taken some steps and none of your assets are going through probate. They're all passing by beneficiary designation, but you are married. You've left your spouse nothing because that's what you both agreed to. This is our second marriage. I got kids. You got kids. We're good. We have our own assets. We're going to leave them to our respective children. We both agreed to that. There's no prenup. There's no postnuptial agreement. Your spouse has a right to make an elective share. This is where they can make an election to take 30% of everything that you own. And I mean everything. There are some exceptions, but for the most part, it's everything. Doesn't matter if the asset went through probate, if it passed by beneficiary designation, if it was in a revocable trust, it's 30% of everything. This, though, is an active election they have to make. So they have to either file it in the probate court or they have to open a probate and then file it and then go after those assets. So it doesn't happen automatically. There's a way you can mitigate the damage of that, and that's by including in your trust an elective share trust. So instead of your spouse making that election and just grabbing 30% of your assets and heading for the hills, you can put that money in a trust for their benefit that will satisfy the elective share. And then upon their death, it will go back to wherever you want it to go, your kids or someplace else. All right. Yes, I will say the question slower. Sorry. I guess, Jenny, can anybody see the questions or is it just me?
It's just you. What I can do is I can post the question so everyone can see that.
I'll speak slower. Okay. Yeah, the beneficiary designations are interesting and really confuse people. We see a lot of confusion around that. I get a lot of questions about, should I name a beneficiary on my checking account? Yes, it's no different than any other account that you have. Any financial account that has any money in it. There's no threshold for probate. I didn't explain earlier, there is a formal administration and a summary administration. A summary administration is for $75,000 or less, not including exempt assets such as the homestead. So you could have $1 million house and $50,000 in a bank account, and it will qualify as a summary administration. A formal administration is everything else, but there's no threshold. So a lot of people think that probate is triggered after $75,000. That's not true. It's triggered by the asset. And if it's not passing some other way, it has to go through probate. Even if there's $100 in a bank account, it has to go through the probate process. So let's see. What about farmland? And the heir is still currently living, but would go to living children at death. How does Lady Bird deed help in this case? I don't think there's any special rule for farmland, so it's still real property. If it's a Lady Bird deed and the life tenant is still alive, then it's theirs. They have the right to use it and do basically whatever they want with it, as long as they're not damaging the property. And then it would pass to the designated remainderman in the deed. Does that answer your question, or is there something else that I might not have touched upon? All right, I'm going to change the slide if everybody's good with probate, because we stayed here a lot for a long time. I could probably talk all day about probate. All right. Guardianship. It's a terrible process. Any which way you look at it, it's a terrible, terrible process. Go back and watch that movie, I Care a Lot, Netflix. Guardianship could be for a minor child. So please, people, don't designate your grandkids if they're minor children as beneficiaries on bank accounts. It could be for somebody who's incapacitated, so an adult. If you're an incapacitated adult, the guardianship is there forever. If your spouse is incapacitated and the court determines that they need a guardian, well, guess what happens with the assets that you thought you used to own together? They're all split. That, we call it the ward. That's the person who's incapacitated. All their assets go under court supervision, financial accounts, real property. It's a terrible, terrible, terrible process. It's time consuming. It's very expensive. It's invasive. It's horrible. For minor children, it terminates at the age of 18 and they get all the money. So at age 18, the guardianship terminates and all the money is going to them, and there's no stopping that. So it's not a good place to be. It is absolutely a last resort. We will talk in our next slide about different documents and how we avoid all these terrible things. All right, so what documents do you need? It's fairly straightforward. You know, everybody's situation is somewhat different, but these are definitely documents that everybody needs. And some of them, you need them when you turn 18. So a will. We discussed a will. It's your very basic document. It says who gets what, who's in charge of administering your estate. This is also where you will name guardians for your minor children, 18 and under in Florida. Some states are a little different. You'll designate your personal representative here. You may make provisions here for your remains. So if you want to be buried or cremated, that's about it. A will can actually have trust provisions in it. So if you don't do a separate trust, you could put trust provisions in your will. It's called a testamentary trust. And it's not as good as having a separate trust, but it's better than having nothing. You know, a will alone is not the best plan, but in certain circumstances, it can be really, really, really important. If you don't have a will, something goes through probate. Again, it's passing through our intestacy rules, which is going to go down the line of the statutes according to who's alive. If those people are not the people you want to get your stuff, then having a really basic will could be really, really, really important. But a trust is better. So a trust helps avoid probate. It helps avoid guardianship. It sets up a nice path for somebody to be able to manage those assets and follow the terms of the trust. It provides for lots of protections, which we'll talk about in another slide. It's a great tool. Almost everybody should have one. Occasionally, somebody really doesn't need one. They really don't have any assets. Maybe they have just a home and maybe just a checking account, and their kids are older and nobody has any problems. In which case, maybe you get by with a ladybird deed and a will. Healthcare surrogate designation, living will. This is for medical decisions and accessing medical records. Super important. If your kids turn 18, they absolutely should have this. If they go away to college, you're not going to be able to get any information if something bad happens to them. Absolutely have your kids sign one of these when they turn 18. But for yourselves, this way you can designate who's going to make medical decisions for you, who has access to your medical information. It's not just between spouses. This is one place where a spouse can make decisions for you, but they don't have access to your medical records because of HIPAA. So they need this document signed. But think next level. We're always thinking several steps out when we're doing estate planning, because nobody's going to live forever. Things happen. Nobody anticipates all of the terrible things that happen, like condos collapsing and bridges collapsing and people driving through other people's homes. And the roads in South Florida are probably the most dangerous place to be. My son is a teenager and he has a license and a car. You should all be scared out there, please. It's very dangerous on the roads out there. So designating somebody to make medical decisions for you beyond your spouse, or if you don't have a spouse, really, really important. But the durable power of attorney is one of the most important documents you can do. There is just no replacement for this. This gives somebody the power to make financial decisions for you while you're alive. So this person can pay your bills. They can sell things. They can buy things. They can transfer things. They can sometimes designate beneficiaries on your financial accounts if you forgot to do so. They can modify your trust sometimes. They can do all sorts of things. They can speak to people on your behalf, call up your insurance company and say, why did I get this bill? Are you going to pay for this? They can speak to your financial advisor. It is a very powerful document. You do have to be careful with it. You have to make sure that you designate people that you trust in here. But it is oh so important, because what happens when you don't have a healthcare surrogate or a durable power of attorney? You're in a guardianship. The guardianship courts will not appoint a guardian if there's a lesser intrusive means, such as healthcare surrogate and durable power of attorney. They will look to these documents to say, oh, you have this, you've appointed this person. When you were okay, this is the person you must have wanted to make these decisions for you. Therefore, you don't need a guardian. Win. All right, questions. Please explain revocable versus irrevocable, and when is one better than the other? So almost in most cases, you're going to see revocable. And that means you can change your mind. You can revoke it. You can amend it. You can do whatever you want with it. And while you're alive, the trust kind of doesn't exist. It doesn't exist for tax purposes. So you don't have to file tax returns. You don't need to get tax ID numbers. It's just you. Typically, you are the grantor or the settler, the creator of the trust. You are the beneficiary of the trust, and you are the trustee of the trust. So you wear all three hats. You're in charge. If you became incapacitated, your successor trustee would take over, whoever you named in the document. They only have a duty to you. They have no duties to any of the remainder beneficiaries that come after you. Their only responsibility is to you. If you've given your agent and your durable power of attorney the ability to modify the trust while you're alive, they can do that. Sometimes that really, really comes in handy under certain But while you're alive, why might you do an irrevocable trust? Typically, the big reasons are estate tax planning. That's one of the big ones. It has to be irrevocable because in order to get something out of your estate for IRS purposes, you can't have any ownership or control over it anymore. So it has to go into an irrevocable trust. So that's typically something that you're not benefiting from anymore. Also for creditor protection. But it is not as common as you think because, again, you don't own it. You're not supposed to really benefit from it. You've really given up control over it. Somebody else is the trustee. You're not the trustee. There's usually going to be some sort of discretionary distributions. So it's not for most people. Revocable trust is what you're typically going to see in estate planning. But for, wealthy clients with large estates, we're definitely using all sorts of different types of irrevocable trusts for tax planning, estate tax planning. You may use one to make gifts to grandkids or your children if you want to make a permanent gift to them, and you don't want to put it into something like a custodial account, which is basically just a regular bank account that passes over to the child when they turn either, depending on what state you're in, 18, 21, 25, but it's their money then, and they can do what they want with it, and you can't really stop that. So you might put something into a trust for gifting purposes. All right. Next. Why do you need a trust? Okay, so we've talked about it avoids the probate process, only if it's properly funded, though, of course. A trust alone is just a piece of paper, and it does nothing unless things are actually titled in the trust. So, for instance, we will actually do a new deed for real property to title it into the trust. You may go to your bank and change the name of your bank account into your trust, or you may designate your trust as beneficiary on the account, and that's the same, similar, not exactly the same, but very, very similar. Incapacity and disability. What happens if you die and you leave assets to a child, an adult child, let's say, and they are on disability? They're receiving some sort of government benefits that are based upon their need. Well, they're going to lose their benefits. Or what happens if they're incapacitated? So let's say you did a ladybird deed. So the title passes to the kids, free of probate. Yay, we won, no probate. Well, maybe one of your kids is incapacitated and they can't sign legal documents anymore. And they didn't do any planning. Well, now they're in a pickle because they can't sell that property because that child doesn't have any representative to be able to sign documents. So if it was in the trust, that would all be covered. We always put special needs trust provisions in our trusts. The trustee has control and can manage the assets that are in there for any incapacitated or disabled beneficiary. It keeps your distributions confidential because a trust is privately administered. A will is public record. Anybody can go online or to the courthouse and pull up anybody's will. It's public. It's a court proceeding. Trusts are confidential. Protection from spouses and creditors. I don't know about you guys, but most of my clients do not want their sons and daughter-in-laws to get their assets. It's a weird thing. So lots of protection there. It passes to your child or to whoever it is that you're leaving it to. That does not mean their spouse gets it unless you want them to get it. The trust is protected. It is typically not a marital asset. Of course, we go back to what I said earlier, as judges are human and they make decisions that sometimes are good and sometimes are bad. But for the most part, this is a great way to protect your assets from spouses and then from their creditors. So you can't protect yourself from your own creditors, but you can protect your kids or your other relatives from their creditors. So if you leave stuff in a trust for them and you die and they owe a lot of money to people or they're in a bankruptcy, well, they can't get at those trust assets because they're protected. All right. Common misconceptions.
Good question, Sam.
Yes. All right. Why do you need to refinance a home to remove the name of a deceased person and have your name added? So that's kind of a tricky one. Remember, the loan itself is in their name. The lender never agreed to lend anybody else money other than that decedent. So the loan stays in their name. The title can be manipulated by anybody, right? We can do a deed. You can do your own deed. You can do one on LegalZoom. That's the title of the house. So the title can easily be transferred, but the loan is still there. The loan, somebody lent money to that decedent. The mortgage is merely the security for that loan being repaid. So the actual, everybody refers to a mortgage, but it's really a note. It's a promissory note, and the mortgage is just securing that debt. So when somebody dies and they owe somebody money, it needs to be paid back. That's just, the process. So if somebody wants to retain the real estate, the real process, the right way to do it is to go refinance or pay off. If you have money, you just, pay off the debt. If it's sold, it will be paid off. You can't ever, the banks will lie to you. So if somebody dies and you contact the bank and tell them, hey, Bob died, and I'm the surviving spouse or I'm the child, they will tell you a bunch of nonsense, like fax us the death certificate and fill out this paperwork so you can be added to the loan. It is just lies that they spew. I don't know why they even say this, because that is just not what happens. There's no such process. I don't know why they say it. I don't know if they're trying to trick you into something or if they truly just don't know, but there's just no such process of that. They don't ever add anybody to a loan. Okay, common misconceptions. Wills avoid probate. We went over that. They do not. They do not. You can have a will. You still will end up in probate if you die owning assets that have to be probated. The will controls the process once you're there, if it's a valid will, but it will not avoid probate at all. Your primary residence will pass to your children if your spouse is not on title. No, doesn't matter if they're your kids together, kids outside of the marriage. Your primary residence will pass life estate to your spouse, remainder to the kids. And when they don't get along, there's a problem. Okay, you can disinherit your spouse in your will or trust. You can try, but it doesn't always work. So as you see with the primary residence, no, they're going to get it no matter what. And then, of course, there's the elective share, 30% of everything. But they have to actually elect that. Your will controls the disposition of all your assets. No, anything that passes by beneficiary designation, anything that's in your revocable trust, or anything that is jointly owned with rights of survivorship, all pass like that and has nothing to do with what your will says. Your estate will pay a lot of tax if it has to go through probate. Big misconception. No, you'll pay me a lot of money to do the probate. You'll pay the court money for filing fees. There may be some other things you'll pay. You'll pay creditors for sure, but there's no additional tax that has to be paid for probate. Your estate may be subject to tax. There could be income tax. There could be estate tax. Florida does not have an estate tax. The federal government has an estate tax, but the exemption there is $13.62 million right now. So not a lot of people are paying estate tax, but some states have a pretty hefty estate or inheritance tax. And even if you are a Florida resident, if you own property in those other states, you may be paying tax, but not as a result of probate. You can give away $15,000 annually tax-free, true and not true. You can give away $13.62 million one time tax-free. You can also give away $18,000 every single year tax-free without using any of your $13.62 million exemption. So some reason everybody's stuck on this $15,000 thing, but now it's been indexed for inflation. It's gone up to $18,000. So if you are wealthy and you need to reduce your estate for estate tax purposes, This $18,000 is a complete freebie. Every single year, as many people as you want, give it away. Okay, we have come to the end. Did we get any other questions so far? No, but feel free to ask some. Again, I just want to remind you to follow us on social media because we put lots of great content out there. Any topic suggestions you want, please let us know. Let's see, any other questions? Trust or private? Since trusts are private, do beneficiaries of trust have a right to see the trust, or can successor trustee refuse to let them see it? That's a good one too. Beneficiaries have all sorts of rights, and it depends on, depending on what kind of beneficiary they are, depends on what kind of rights that they have. So if they are to receive, let's say, a specific amount of money, so beneficiary A gets $20,000. Once they get that money, they're done. They're not entitled to anything else because they received everything they could possibly receive under that trust. So that's a tactic we use sometimes for difficult beneficiaries. If you are what we call a residuary beneficiary, meaning you get a percentage of whatever's left, then yeah, you have all sorts of rights. You definitely have a right to see the trust. You have a right to know what assets are in the trust, how they were valued, annual accountings if it's an ongoing trust, or one accounting if it's going to, end after the administration. You have the trustee has a duty to inform, to account, to be loyal to those beneficiaries. For instance, a trustee would be precluded from buying an asset from the trust, even if they paid fair market value for that asset. It's an automatic breach of their duty. They would need to get court approval or beneficiary consent in order to do that, unless the document clearly gives them the right to do that. So trustees are held to a very high standard of care. They are fiduciaries. It's a thankless job, as I said, but we need people to do it, so don't get too scared away. It's an important role that should be taken seriously, and when you're doing your documents, you do have to take seriously who you're choosing to be in that role. So beneficiaries have rights, and but when the trustees aren't doing what they're supposed to be doing, the beneficiaries can take them to court. The benefit, kind of like from the trustee side of not being in probate, is that there's no court proceeding. So the beneficiary has to go hire a lawyer and they have to file something in court to get something going. If you're in probate, it is so easy for a problem beneficiary to cause trouble. They just file something. They'll be pro se. They'll just file something, in the case and cause all sorts of havoc. So staying out of court is really ultra important if you know that there's going to be some sort of problem with beneficiaries. And if you know somebody's going to be a problem, then we have discussions. Instead of making them a residuary beneficiary where they get a percentage, give them a certain dollar amount, or better yet, designate them as a beneficiary on a bank account, and they get that bank account, and that's it. Then they're not part of the trust at all. Any other questions? I'll give you a second. There's our pop-up with our contact information. Any last second questions, please put them in the chat. If not, you are always welcome to email us, contact us anyway you can. We're happy to answer questions. I hope everybody learned something tonight and got some value out of this. We will be doing these more often on different topics, so stay tuned. Thank you all for coming. We appreciate it. And happy Valentine's Day. Thanks, everybody. Have a great evening.